show, there's been a lot of Durk hate engineered and manufactured on the internet by the powers that be of the algorithm. And as the days go by, it's only gonna get worse. But surprisingly, a few Durk diehard fans, according to the feds, seem to take matters into their own hands and risked it all federally by leaving voicemails to the judge stating that Lil Durk and Dee Dee is innocent. And if they was to get life, oh, they gonna burn this motherfucker down. And not only burn it down, but burn it down to the motherfucking crowd. I said, oh wait, they done unlocked a new level of trolling out here. And check it out. And ended the conversation by saying, think it's a game, bitch. I mean, it wouldn't be wise to play with the government like that, because when you calling in, they got your IP, they know your whereabouts, and they coming to see about you expeditiously. Now, these ain't my words, these the words of the federales. Now, the feds claim another Durk supporter issued a similar threat to the prosecutor stating, free Durk or get murked. Yup, they said free Durk or get shot. Against all odds, it's looking like all-out warfare, and it's the first time I heard the fans make a bold statement and threaten to slide on the U.S. magistrate over their favorite musician. Look, I know we living in the times of trolling, but parasocial relationships at an all-time high. Unlike the historical one-sided connection with TV stars before social media, because today's digital platforms offer manufactured intimacy that make these bonds feel more frequent, complex, and intense. You know what? And I don't even get confused no more when fans add themselves into the war of their favorite art. I ain't mad at you.
We 646 on BD on game like that. Homies don't play with that. Period.
So the government is claiming that Durk's influence and his history of intimidation runs deep. So with that being said, the feds is even claiming that Durk supporters pose a risk to juror safety, making their argument for anonymous jury more applicable. And all this go to show is that the trolls are playing a more pivotal role in this case than we think. Stemming from the initial fan-made editor Quando Rondo screaming and yelling no on the ad-libs to where we at today. I mean, if I got on the horn and called a federal building and threatened to blow it up to ashes and dust and left voicemails claiming to take out the federal prosecutor and judge, man, what? I would've fucked around and made CNN and y'all would never hear from me again. You know what I'm talking about? That would've made an example of my dumb ass and ducked me off and hid me like an Easter egg somewhere, boy. I'm talking about, ain't nobody heard from Drill Time? Shit, last I heard, they done turned your man into crocodile bites over there in Alligator Alcatraz. Fuck you talking about? Think about it, I never met this man a day in my life, so how could my stupidity hurt or help or hinder his case in any fashion? So the fans ain't buying it, they calling it cap and reject their deposit because they saying obviously this proved that this case ain't strong enough, so they throwing anything at him to make it stick, hopefully, like spaghetti on the wall. But they got your boy Durk looking very treacherous. They said the government comparing Durk's structure to organized crime like the Mexican mob. And Durk, the leader, that uses his money, influence, and power to endanger individuals that he perceives as a threat. Feds also claim that Durk was caught with an Apple Watch in custody. And instead of taking full accountability, he tried to destroy it before he got caught with it. So the feds view this as obstruction and potential witness and tampering. All the more reason to push for anonymous jury. And a text chain that they label Montaduke feud. Feds also claim that Durk was frustrated with Oblock because they wasn't properly retaliating for King Von. So he declared, I'm finna pipe it up. And Booney Mo responded, blood, it's green. I'm getting shit together now. No phone. Hey, I wonder if the feds really trying to get Booney Mo to corroborate this evidence. Because the last we heard of Booney Mo, he was doing a 7-ball in Iowa for a few tinas of cocaine. The feds even detailed they got a rat in the cut that they keep well fed that's ready to paint that picture of Durk and color him bad by saying he was commissioned to kill the first person that he spotted in Oblock. But he ended up not going through with the move and he ain't never get paid. The feds also caught wind of the Lamron feud with Durk in his neighborhood when they was going back and forth on the internet and trying to build a case based on lyrics from Lil Durk unreleased song Survivor, referring to group chats, cars that was given the slide, and firearms, etc. I mean, I don't know. To me, it seemed like the feds reaching. Remember, Durk wasn't mentioned in the original indictment and he tried to post bond, then the feds immediately introduced the Stephon Mack trial and said Durk was responsible for that hit. But he was never charged in Chicago for it and never will be after 3 years of investigation. Remind you, this case was supposed to be originally a murder for hire case on Quando Rondo that took place in LA. So recently, what you've been seeing in the media is the government response to Lil Durk legal team filing new motions. Since Durk is being charged with murder for hire and the indictment claimed that Durk offered a bounty for Quando Rondo murder, Durk's defense demands details on what was offered and how. Durk lawyers argue that the indictment is too vague, And there's no clear evidence of coded language or payment. And the allegations the feds are making lack time, place, and metric specifics. And lack of these specifics could violate Durk constitutional rights under the 5th and 6th Amendments and endanger his due process. So no matter how you feel about Durk and all the preconceived notions, in America, he's still entitled to a fair trial. So in a nutshell, Durk's legal team filed a new motion to dismiss based on the vagueness of the second superseding indictment. And if the motion to dismiss isn't granted, Durk's defense is demanding a bill of particulars that reflect the theory upon which the grand jury rested its charging decision and indicted him for in the first place, giving Durk fair notice against the allegations against him. In this bill of particulars, the defense needs the feds to specify this coded language that they claim Durk used. They also need to clarify the nature of the bounty, the date, the time, the audience, and the circumstances related to the allegations in this indictment. This request was made under the Federal Rule of Criminal Procedure 7F and the 5th and 6th Amendment, and they're asking for the feds to produce these documents in 45 days. Instead of acknowledging and sending these documents, the feds fired back by pushing for an anonymous jury, citing Durk's alleged influence over associates and a pattern of organized crime. By making accusations that Durk was coordinating hits on Oblockians for not sliding for Vaughn, and also funding criminal activity and sending threats through song lyrics and coded text group chats, including a seized Apple Watch that he was allegedly trying to destroy. However, Durk's defense state that the allegations against him are primarily based on information from a paid FBI informant that's a former gang member with a criminal history. Now, who is the informant? I don't know. We just gotta be patient until the trial starts. But usually, paid informants with criminal histories and gang ties wouldn't have any credibility to jurors. But if the feds can secure this anonymous jury, this possibly could change everything. The use of anonymous juries don't only conceal the juror's identity, it can also create a prejudicial atmosphere, suggesting to the jurors that the defendant is dangerous and guilty, therefore undermining their presumption of innocence. Withholding information limits the ability of attorneys to question prospective jurors and discover potential biases. Some studies suggest that anonymous jurors may return with more guilty verdicts, and Boosie said they did the same thing to him when he was on death row. He said the feds trying to taint the jury and make the jury mad so they'll be ready to convict and go home. It's not every day that the feds go against the best lawyers in the world. So if they don't have their case set in stone before presenting it to the grand jury, they leaving a lot of room for that 90% conviction rate to decrease. Hey, I need y'all to pay attention to this former federal prosecutor, give his breakdown and what he really think that the feds got on Durk and his anonymous jury really needed due to these circumstances.
Durk's team is doubling down with yet another motion to dismiss. That is where we left off. Things have escalated. We got a lot of developments to talk about. I want to bring on friend of the show, former federal prosecutor Nima Rahmani. Nima, thank you so much for taking the time. Always love having you on here. Okay, let's start here from big picture of the case. How common is it for someone to face federal charges for ordering a hit, ordering an assassination, right? Even if they didn't pull the trigger themselves. Is it common?
Jesse, always good being on. It's usually not common. Usually they'll throw that in with the actual murder or some sort of RICO charge. But here, the feds apparently believe that Lil Durk is the one who's the shot caller, even though he's not pulling the trigger. We do see these murder for hire cases stateside more, but the feds are really interested in this case for some reason, maybe because of who Lil Durk is.
Do you think that there's strong evidence that he directed this in some way, was funding it in some way, was the mastermind behind it in some way?
I think there's evidence. Is it a lock? Not necessarily. A lot of these federal cases, as you know, by the time they go to the grand jury and get an indictment, Jesse, it's a done deal, right? I mean, it's just a matter of whether they're going to plead or be convicted at trial. But here, it's a little bit more attenuated. Obviously, we'll see what evidence comes out. Look, you're relying on cooperator testimony. You and I have talked about it a lot, right? Those are people that are often criminals. You got to corroborate that. Now, they have text messages, but some of them are pretty cryptic. And, you know, to the extent that Lil Durk's credit card was used for ski masks, hotels, and so forth, that's certainly enough. But for the conspiracy, for the solicitation, you usually need something more than, you know, just some credit card charges.
And it leads into something the defense is doing, where they're challenging this indictment. My understanding is saying it's impermissibly vague. What does that mean to you? Is that a common defense? Does it usually work?
Jesse, it's not a common defense at all. And usually it doesn't work because really the remedy is for the prosecution to cure and be more specific in the indictment. When you're talking about a conspiracy, when you're talking about solicitation, you really need to identify those overt acts and furtherance of the conspiracy, the evidence of the solicitation for the murder for hire. And in this particular case, I think the defense's theory really is the best defense is a good offense. They're trying to file these motions, not because they necessarily think the indictment's actually going to be dismissed, but to put the prosecution on its heels a bit.
And the pendulum swinging, right? Because now let's talk about what the feds are doing. This is the new allegations. This is what I wanted to bring you on for. So the feds have allegedly quietly introduced this new explosive claim into Durk's legal case, that he didn't just order a hit on Quando Rondo, that he also put out hits on members of his own oblock crew, who apparently failed to retaliate after King Von's 2020 death. This was a friend of his. That's according to reporting from Hot New Hip Hop, The Source. According to those reports, federal prosecutors, they plan to present testimony from a witness who claims that Durk personally gave those orders to oblock associates. Now, this new theory, it frames this case even more broadly. So not just a revenge plot, but kind of like this possible internal purge, an effort to maintain control, demand loyalty, punish dissent within his own inner circle. Now, that being said, none of these additional claims have yet led to new formal charges against him. But Nima, let's talk about it. Can you explain what it means legally if prosecutors allege that Durk ordered hits on his own associates, even if no new charges have been filed as of yet?
Jesse, there's a couple reasons why you want to do this. Sometimes the feds will pile on to try to gain leverage and to force some sort of plea. But in this particular case, it's probably to try to dirty him up. You remember, the 80s movies where the villain turns on his own crew, really? That's something that jurors are not going to like. Now, look, I'm not saying this is substantiated, but it may be part of the bigger story here. This wasn't just a hit on Rondo, right? With Robinson being the innocent target. This was, like you said, a purge. Durk was upset because his own crew didn't avenge the Vaughn death. So he wanted to kill even members of his own inner circle. Again, not saying that the prosecution can prove it, but if they can, I don't think jurors are going to like little Durk at all.
And by the way, just to be clear, Rondo has not been, charged or connected to the death of Vaughn, but it is interesting what this theory is. I do want to make it clear that what is coming out right now is prosecutors seem to say they plan to present witness testimony that Durk gave these orders. If that's the case, how credible are they, especially if they're testifying in this trial in federal court?
Yeah, I'm kind of shaking my head. And this is me personally, Jesse. And look, I prosecuted, cartels, organized crime. I really don't like to rely exclusively on the testimony of cooperators, right? Look, they're always going to get torn up on cross-examination, that they have an axe to grind, they're disgruntled, they're lying to save themselves. It's fine if you have corroborating testimony, right? So maybe they have text messages again. The messages seem a little bit cryptic to me. So you got to be really careful when you're just relying on cooperator testimony. You got to buttress it with something more. And the last thing you want to do in these types of cases, and we've seen them, like YSL, when you overcharge, it adds confusion, the case drags out, and you end up getting nothing as well. So hopefully the prosecution is going to bring some evidence here to substantiate what they're alleging.
If they don't add new charges, and I'll talk about what those could be in a second, if they don't add new charges, this could be part of the case, though? This technically could be part of the overall case against Durk, the federal case, what he's currently facing?
It could, right? It could be the 404B, right? Part of the motive, the plan, so that could come in.
Sentencing, maybe?
Sentencing, of course, we know all that relevant conduct comes in, right? We saw that in the Diddy case. So I think a judge would allow it in because it is relevant to this scheme. Again, the defense has to be provided notice, obviously any discovery related to it, but it's going to come in. Look, at the end of the day, you're talking about a federal murder for hire case, right? It could carry, we know it carries a potential life sentence, but even a potential death sentence. Now, obviously, the feds haven't filed notice of intent to seek the death penalty. So it's not going to add anything in terms of the potential exposure, but it can certainly bring more bad facts in the case if they're substantiated.
And support their case. Okay, let's say they decide to bring new charges with respect to this. Is that something you expect to see, and what could those charges be?
It'd probably be, conspiracy or attempted murder, right? And, we're talking about a January trial date, so it's pretty late in the game. I don't know if the judge would allow it. If the judge did, the defense may ask for a continuance, and I think the judge should probably grant it, right? If you're adding additional counts 3 months before your trial, probably a little bit late, in my opinion, to keep that trial date. Again, obviously, it's the defendant's right to a speedy trial. If Durk's team wants to keep that date, they'll move forward, but it may be a reason to kick this out.
But not a different trial, not a different case, not a separate case. Like they wouldn't bring a separate indictment, had nothing to do with Quando Rondo, separate indictment regarding him allegedly taking out hits on his own people. That's not something you expect.
No, not at all. It would be part and parcel of the same case.
Okay, now I want to talk about something else. I want to talk about the second motion to dismiss by the defense. So on October 6th, Lil Durk's legal team filed a second motion to dismiss the federal indictment. And they argued once again that the case against him is too vague to be fair. So per reporting from Hot New Hip Hop, Durk's attorney, Drew Findling, lays out the problem. That while the indictment claims that co-conspirators carried out acts at the direction of Durk, flying to LA, tracking and stalking Quando Rondo, attempting to kill him by gunfire, procuring firearms and other equipment, that it fails to provide specifics about what Durk himself allegedly did or said. As Findling writes, while the indictment alleges that the co-conspirators carried out various acts at the direction of Mr. Banks, flying to Los Angeles, tracking, stalking, and attempting to kill TB by gunfire, this is Quando Rondo, and procuring the firearms and equipment used to do so, it fails to give any specifics. When, where, how, and to whom did Mr. Banks give these alleged directions? To ensure the basic fairness of this trial, the defense is entitled to know. He adds, what the indictment fails to tell us are the very things the defense is entitled to know, the operative facts underlying the government's theories of Mr. Banks' guilt. There is no allegation here that Mr. Banks physically participated in the stalking and shooting at issue. And Durk's legal team has also called the indictment, as we mentioned, impermissibly vague, demanding clarification on the government's allegations. Quote, it leaves the defense to guess as to the government's theory of guilt, and it leaves the government free to change that theory as its cooperators' stories morph over time to meet the demands of a conviction. Nima, do they have a point? How much do prosecutors actually need to lay out for the defense? This is, again, you mentioned Diddy, big part that was litigated leading up to his trial. How much would they be made aware of what the theory of the case was, what the evidence was going to be presented? How much do prosecutors legally need to lay out and tell the defense?
Yeah, it's a due process issue, so the defense has to be given enough information to be put on notice of the nature of the allegations. But as far as, dates and times and specific statements, look, the indictment's not evidence, right? That's all witness testimony that's going to come out at trial. So I think the prosecution, as long as they can allege the unlawful agreement, the overt act and furtherance of the conspiracy, and generally lay out the actions of the co-conspirators, I think that's enough, and I don't think the judge is going to dismiss based on vagueness.
That idea of, hey, they could just change their theory, they can change it as cooperator stories change, that's not going to persuade a judge? You don't think?
Well, that goes, in my opinion, that goes to the weight of the evidence, not the admissibility, right? So you're not going to get a new indictment, right? You can cross-examine folks if they change their story, right? And again, none of this is evidence. Even if they put a specific statement in that indictment and the witness were to testify to something different, the witness's testimony controls, right? You can cross-examine on anything, right? You can allege that, well, didn't you previously tell law enforcement or prosecutors that it was on such and such date? Now you're telling us it's on a different date. I mean, that's fertile grounds for cross in any case, but I don't think it's grounds to dismiss the indictment. That's a pretty extraordinary remedy.
Well, a hearing on this new motion is scheduled for November 18th, so we'll keep a careful eye out on that. But I do want to move on to something that is very troubling, okay? Alleged threats against prosecutors and judges, and a request for an anonymous jury. Let's talk about this. So authorities reporting that supporters of this rapper have issued multiple threats targeting key figures in the case. According to an FBI report that was filed in the Central District of California, fans of Lil Durk have allegedly vowed physical harm and gun violence and even arson if the Chicago rapper is convicted. The threats have included 4 voicemails that were apparently left on a U.S. magistrate judge's phone. One message reportedly stating, "If they get life, I'm gonna burn this mother bleeper down." They being Lil Durk and one of his co-defendants, DeAndre Wilson. Now, the alleged intimidation extended apparently to the prosecution team as well. Assistant U.S. Attorney Ian Yaniello, one of the lead prosecutors, reportedly received a call from an unidentified male who warned, "Free Durk or be shot." Now, citing these incidents, the government has requested an anonymous jury. Writing in court filings, defendant supporters have already attempted to intimidate individuals connected to this case. Nima, I have a few points about this. First of all, have you seen something like this before? If it's true, have you experienced something like this before? How common is it?
Look, I got threats when I was a federal prosecutor. It's part of the job, Jesse. I mean, if you're going after the bad guys, they're going to make threats. Now, a lot of these threats are not substantiated. And look, it's easy for me to say, now that I'm out of the Department of Justice, to say it's not a big deal. Don't worry about it. But if you're a judge, if you're a prosecutor, this is what you sign up for. So I'm sure it's not fun to get threats from fans or the defendant or, his family. But this is not unexpected. And I got threats all the time when I was a prosecutor.
The idea of this justifying an anonymous jury. And what is an anonymous jury? Don't we always have anonymous juries? Don't we not know the identities of these people? So what does it mean to have an anonymous jury, and would this justify it?
So on Law and Crime, obviously, when we televise the trials, they never show the jurors, right? But the lawyers, they know the identity of the jurors, right? That way they can do their research on social media, see what their political affiliations are, if they've said anything about the case. Truly anonymous jury, that information is even withheld from the lawyers. Again, not very common. It's really, we talked about different extraordinary remedies, pretty extraordinary. Obviously, the judge in these types of cases has a lot of discretion on how to handle the jury, but I would be surprised if we get an anonymous jury based on some voicemails and that type of thing. Look, this is social media. I'm sure there are folks who are watching, they love me and you, Jesse, but people say all sorts of crazy things. So I don't think it's enough to get an anonymous jury just yet.
Would they be in a separate room if that were the case? Like, do they hear the case? They hear the trial from a separate room on a camera or something? I mean, how would the defendant or everyone else not know who they are?
Yeah, I mean, that's a possibility. We've seen that. Sometimes they'll have 2 juries for different issues in the case. One will be in another room. It's possible, but again, like, if you're the jury, think about it. I mean, you need to assess the witnesses and their credibility. You need to look at them eye to eye. So it really becomes problematic when you start doing things like this. Again, I would be very surprised, based on what we've heard, some voicemails, if we do get an anonymous jury.
Okay, I want to now move on to the Apple Watch situation. Now, this is another dramatic twist in this Lil Durk saga. So prosecutors, they revealed in a filing from October 6th that the rapper was allegedly caught with an Apple Watch in jail. Now, this is a device with cellular capabilities, and that he allegedly tried to destroy it once it was discovered. The motion that was filed in support of a request for that anonymous jury reads, in late August 2025, BOP officials seized an Apple Watch with cellular capability from defendant. Even more troubling is Banks' conduct after he was caught. Rather than accept responsibility for this violation, defendant allegedly obstructed the investigation, attempting to damage and/or destroy the communications device. And authorities point out that this wasn't an isolated incident, that Durk was accused last December of making unregulated 3-way phone calls from the Metropolitan Detention Center, the MDC in Los Angeles, where he's currently jailed. So these repeated alleged violations are being used to argue that there's a real risk of witness tampering in this case, especially given, quote, the expansive reach of Durk's Only the Family or OTF network. Nima, how serious is this allegation here? Do they know, or they're alleging that he tried to destroy it? Let's start there and we'll talk about whether that justifies taking some action.
So look, it's serious. but it's not uncommon. We talked about this with Eric and Lyle Menendez, right? And this is one of the reasons they weren't granted parole. You can't have a cell phone in prison. Doesn't matter whether it's state or federal, right? So an Apple Watch qualifies for that. Look, is it a violation? Yes. Is it grounds for something serious in terms of the remedy in the case, like an anonymous jury? No, Jesse, it's just something that happens and it's dealt with by BOP and other prison officials, and they deal with it. It shouldn't really affect the case unless they charge, obstruction or something related to witness tampering.
And again, does it justify an anonymous jury? Does it justify adding added protection to witnesses in this case?
I don't think so, Jesse. You're talking about something that, again, even though it's a violation, it's not uncommon. The three-way calls, we talked about that in the Diddy case, right? That was something that he was doing as well. So, look, it's wrong, it's not right. But again, to completely change how we handle the criminal prosecution in this case doesn't make sense to me. It should just proceed as normal.
Oh yeah, the feds ain't playing fair, and if you ain't got over $1 million, you might as well sit your ass down somewhere and stay out the streets, cause you see how they coming, and it'll be interesting to see how this play out. What y'all take from this? Is Durk cook fried bologna, or do we still got a fighting chance to make it home and see his family again one day? And hit the like button, share this to spread awareness, and if you ain't subscribed to the channel, it's a good time to do it now. Man, put them guns down and boil your fish up, and make throwing hands great again, and I'll catch you in the next one. Taint TV, I'm out.